months. I work on the UVM campus, and I began to be approached from workers from Sodexo who were having a couple of problems suddenly with their working conditions. And the first involved a reclassification of full-time workers, or I'm sorry, part-time workers to full-time. No, I have that backwards. Full-time workers to part-time. And so at that point, I communicated with Commissioner Noonan, and it was her determination that what Sodexo was doing on that front to classify workers who had previously been full-time with full-time benefits as part-time workers with part-time benefits was within Sodexo's rights in an at-will state like ours. So I had hoped to have Sodexo come in and talk about that, their reasons for doing it, and answer questions about it. They've decided they'd like to come in at a slightly later date. They weren't ready today. But
I spoke to their lobbyist and suggested he ought to be here today, but I don't see him.
I said the same, but in any event, they had ample warning to come to
I would
us.
say that this is a bigger issue than just Sodexo, because there's fear among a lot of Vermont workers. I know that the nurses at Vermont Hospital were convinced that the hospital was trying to switch everybody over to part-time. Of course, when I went to the hospital CEO, he just laughed. So there's no such plan.
Yeah.
But that's a fear that is rampant around the state because of the ACA and other things, that there might be incentives for employers to switch people over. And so it's better that we stay in front of the curve than be behind it.
Absolutely. And just to clarify, in the case of Sodexo, when they first were communicating with workers, they were very clear that they were doing the reclassification because of the Affordable Care Act, known often as Obamacare. And after speaking with them several times and having the issue come out in the media, they eventually changed what they were saying so that they weren't saying that the Affordable Care Act required them to do it, but that it was a good time to do it to align with the Affordable Care Act to remain competitive in the workplace. So I think my general understanding now is that they've essentially admitted that the Affordable Care Act does not require reclassification, but they've asserted their right to do it under the at-will labor laws that we have. So, but today I really want to focus on something different, which I learned in the course of talking with workers about their situation, and that has to do with the sick leave policy that Sodexo has instituted. So, when I first heard about it, I had a hard time believing that it was so, but it works like this. You have sick days under Sodexo's policy, but if you use them, you're penalized. So if you use your sick leave, you receive points, and then the points accrue just like on your license. If you get so many points, you lose your license for a period of time. So in the case of the workers, and we'll check with, hopefully we have 2 workers here today, but if you receive 3 or 4 points, I think it's 4, you get a written coaching, they call it, and a supervisor comes in publicly to your workplace, pulls you out, and gives you coaching on how to avoid absence in the future. Now my question there is, how do you coach somebody not to be sick?
Do they pay for 2 shots?
Well, it's a good question. But in any event, if you get 7 points, then you can be terminated. And it doesn't matter.
So you're entitled to the sick days, but you can be terminated if you use them?
Absolutely.
So we want sick people serving food.
Right, and I'll pass these around, or I'll ask Meg to copy them. But the forms that they give out when they do this coaching make it very clear that this is a disciplinary action.
Who's the food provider here?
In the State House?
It's not the advocate,
Yeah,
Okay.
it's not.
It's not Sodexo?
Um, And so the documents that they give out say if there are further absences, there will be further disciplinary action, which seems to me to admit that written coachings and points are disciplinary action. So having talked to people about that and having talked with Ledge Council, I asked David to draft up just a very quick piece of legislation essentially outlawing the practice of converting a benefit like sick leave into a penalty system. And so, as we've scheduled it, we had asked David to walk us through this one-page bill and then hear from one worker from UVM and one worker from, is it?
Johnson State College.
Yes, Johnson State College. So, David, do you want to?
You got mine, David?
Sodexo is a huge multinational corporation. They've been very successful in Vermont in getting contracts at institutions of higher education. So if you have a campus in your district, chances are very good Sodexo provides the food service. We got the statistic in the hearing yesterday on Farm to Plate that they prepare 34,000 meals a day in Vermont.
And they are buying Vermont.
They are in a partnership with the Department of Ag to purchase more Vermont products. So they are big, they are omnipresent, and for the most part, I had never heard complaints about them until 6 months ago.
Where's the corporate headquarters?
France.
France.
So,
That
yeah,
would be a good legislative trip.
you could just say your name and where you work for the record, and then just tell us your story.
My name is Deb Proof. I'm a supervisor at the Cyber Cafe in the Baylor Ag Library. I've worked for Sodexo for 18 years. And about 2 years ago, they started this new point system. If you're late for work or if you're absent, which has really had a negative impact on everyone there. The point system consists of if you are out sick one day, you get 1 point. If you're out 2 consecutive days, you still get 1 point. Now, if you were to be sick one day and then come to work the next day and then be out on the 3rd day, then you get 2 points.
So Senator Cummings brought up earlier, you don't want somebody sick that's serving food or spreading germs. They don't have any policy that says if you have the flu, do not come in?
They tell us not to. They tell us if you're sick, stay home. But unfortunately, if you stay home, you're going to get a point. And if you get 7 points in a rolling year, you could be terminated. You're suspended for 7 days.
I can understand if you're late chronically, things like that, but
You
if
split
you're
off
sick,
the road last Saturday.
I can tell you, everybody's going to work sick. The people that do not have, the people that do not have sick pay will go to work just because they can't afford not to. If you stay home because you have a sick child, you still get a point. If you go to work and you work half of your shift, and say daycare calls you and wants you to pick up your child, if you work half your shift, you get a half a point.
And am I right, Deb, that if you go to work and you don't want to get a point and your supervisor thinks you look sick and they send you home, you still get a point?
You still get a point.
is there a way for us to get a copy of this policy?
Yes, you have, you have this isn't a copy of the policy, it's the constructive counseling notice that they give you when you have 4 points. Did Meg
I'm
pass
curious
that?
though, did they send something out to the
She's got it.
employees when they instituted this system that is fully explained, and I was
We
wondering
all
if
had
you
to
could get a
sign,
copy of
we
that?
all had to sign off on it.
Did you get to keep a copy of it?
No.
No? Okay. Okay.
I, again, in speaking with Sodexo's lobbying firm, I tried to get them to be here today or to send a representative. They did send a letter, but the letter deals in a general way with the the way they handle benefits. It doesn't answer specific queries about their policy.
Well, I'm gonna ask Meg to send a letter, under my signature on behalf of the committee to Sodexo and ask us for a copy of their policy, and at least we get a chance to see what they're telling people.
I would think that there might be some health violations here to encourage people to come in and serve food when they have the flu, to me is a public health issue.
And also see if you can schedule Dr. Chen to come in and answer questions to us about the state health policy relating to food service and sick employees.
I also think it's important to tell you that in April, my daughter had a tubal pregnancy, and she was told to rest for 2 weeks. But
Does she work at Sodexo?
She does.
Okay.
At the time, she had 6.5 points, and absolutely refused to go, not to go to work. She worked for 2 weeks in severe pain. They knew there was no concessions made for her. And then on one Friday, she could not stand. I had her taken to the hospital. She needed to go into emergency surgery, and I literally had to beg her to have that surgery. I had to call her boss and make them promise they would not give her another point. But that's the way it is campus-wide now.
And just one other thing, if you could speak to in addition to just the point system and the fear about the point system, there's also a public aspect to the coaching sessions when they come in to give you your write-up. Am I right that they come in and pull you aside and?
Yeah, and they give you what they call written coaching. And we were told at that point that if you miss any more time, or that when you reach 7 points, you could be suspended or terminated. I have 2 ladies, I'm in charge of the cafe. I have 2 ladies that work for me. One is 72, another one is 63. They missed 4 days in 1 year and were written up. One of those ladies, and I believe you got a copy of it, actually wrote an apology letter saying that she was sorry for inconveniencing the company and that she promises to only get sick on weekends.
If it's all right, I can read that letter.
Sure.
Okay. It's from, well, I won't read her name, but she did say that I could read the letter. To whom it may concern, I will not sign your write-up as I was sick on Wednesday, October 2nd, 2013, and worked my shift. Got home at 4 p.m. By 6 p.m. I was throwing up and had terrible cramps. Shortly after, was having diarrhea for the whole night until 5 a.m. Time to get up for work on Thursday. Sorry for getting sick on a work day. In the future, I will try to be sick on weekends in order not to inconvenience my job. Although I work in the public daily, I would think you would not want me around students in that condition. But I guess I was wrong. In the future, I will come in no matter what. So she submitted this because they have to sign that they've received the written coaching. So this was her response to that. And again, this is in a calendar year. So this was a woman who was sick for 2 days because of the flu nearly a year before, and then was sick for a couple days at the end of the calendar year, or the rolling year, and technically in that year had 4 absences, and so she was put through this process, which, you know, she was very upset.
Both of them were very upset. There was 2, both employees got written up that day.
David, can you check to see if other states have any legislation pending, or if there's anything that,
Does Sodexo work in any of this?
Oh, yeah.
Oh, yeah.
Okay,
Big.
so let's
And
find
it
out.
also makes it very hard for the supervisors. I mean, I had one lady come into work for 2 weeks sick. And then I said to her, that's it, we had a 4-day weekend, so it's like, you need to go home. And she would not leave. Because she did not want to get the light.
I wonder how many students got sick.
Well, I can
Commissioner
tell
Noonan,
you-
is it legal to have a point system when you're, I was asking the commissioner behind you if it's legal to
And he's going to testify.
dock somebody?
I'm going to give you a preliminary answer, Senator, that I think it may be, but there was a Vermont Labor Relations Board case, and I just texted Tim to ask him. There was a case that the Labor Board ruled on, and it was a state employee case years ago, but it talked about the fact that if the employer allows you to accrue sick leave, then they should not be, they should allow you to use it. That if there was a, and I'm going to see, Tim will write back and give me that information as to what the name of that case was. But I will put our legal staff on this this morning and work with David and Tim to get you that answer immediately.
Okay, thank you.
And I think you should also know that these points are just not if you're sick or if you stay home or to take care of a sick child. The 6.5 points that my daughter received, most of them were because daycare had called her and asked her to come and pick up the child. So every time she left, if she worked half her shift, she got the half a point. She worked less than the half a shift, then she got the full point. So you can't work. And
I'm surprised they're able to even keep you there.
we have lost a lot of the long-term employees believe that this point system was designed to get rid of the older employees, the long-term people. We've had more long-term people quit in the last year and a half than I've ever seen in my 18 years.
And that has to cost them dearly for the training for the new people.
But do you get any kind of salary? Are the long-term people paid at a higher rate than new hires? Or is everybody paid the same?
No, the long-term people do get paid higher rates. There's one woman that just received her 30-year plaque in August and quit. Didn't come back this semester. There's a few people that have done that, but most of us believe that it's designed to get rid of the long-term people.
Has there been a change in the company's treatment over the last few years? I mean, obviously you've been there a long time. Did they used to be a good place to work, or?
It was a good place to work. The reason I went there is my husband's been there for 23 years. And it was, at that time, very family orientated. And that's what I liked about it. But in the last few years, it's just, everything is just slowly being taken away, and there's just, it feels like there's no appreciation whatsoever.
Okay,
Is it a different company now? Did that used to be Marriott?
It was Saga, and then it went to Marriott, and then Sodexo Marriott, and then Sodexo.
Part of the complaint from the workers was that there had been a big meeting. These changes had been handed down at that meeting, and they were told at the time not to criticize the company or to publicize this, especially on social media, or that could be considered creating a hostile workplace environment. So Commissioner Noonan was very helpful in pushing back on that and clarifying people's legal rights. But I just wanted to point out that it was a courageous thing for Deb to come forward. She's been speaking out, and that hasn't been easy.
Presented in some of the testimony that you heard this morning was about employees' rights to engage in activity to complain about what was happening to them. And in this case, there were two or three issues that were presented, but one was the reduction of the hours, as you've heard, that has been put on hold by President Sullivan. One of the pieces that was heard here this morning was about alleged threats if employees were to publicly speak out against this activity, if they were to use social media or any type of public forum to discuss the situation or to talk about what.
So can we take those one at a time?
Yes.
So can an employer in Vermont legally at any point in time change the benefit package?
In a situation where the employee, there's three things. One is that it cannot be done for retaliatory, discriminatory reasons.
Okay.
Number two, it cannot be done if the employee has an individual contract. You employ me in a firm, and you and I have signed a personal contract, I have an individual contract, at which point I would have a right of action against you for bridging my contract terms. Or number three, in a situation where an employee is covered by a collective bargaining agreement and the terms are specified, and outside the terms of those agreed by that collective bargaining agreement, they cannot change.
Would the collective bargaining agreement specifically have to say that they can't change?
In almost every situation, a collective bargaining agreement is, the terms are set until such time as the collective bargaining agreement is expired. In some cases, collective bargaining agreements will also have carry-forward clauses which say if in fact the parties are engaged in negotiations for a successor agreement and those negotiations are ongoing, the employer still may not change the terms of the collective bargaining agreement pending a new agreement. So it depends on, in all cases, I would say, I've never seen a collective bargaining agreement that doesn't set the terms during the term of that agreement, and some do include successor language.
So in the case of, like I used before, I had received a call from people at Rutland Regional Medical Center. Would the hospital, would proper notice, if it wasn't part of the bargaining agreement that they have, be able to unilaterally decide that you are no longer a 40-hour employee, you are now a 30-hour employee?
Generally speaking, the answer to that, if it's not covered by one of those three instances, is that an employer can amend the hours of an employee. One of the things I would point to, though, is that there is often, there have been challenges when an employer has a written policy or an employee handbook that lays out some of these terms of terms of an employee's work situation, that sometimes makes that a little bit more difficult for an employer to amend it. But that is really, that's not necessarily as strong a case. An employer handbook generally is a guide. And sometimes some jurisdictions have said we will give that due weight, but with proper notice, generally speaking, if the employer notifies and says we're now changing, we probably can do that.
And is there a period of notification, or?
Usually proper notification. I would think in a situation like a healthcare change, they would be looking at potentially, maybe a 30-day window would be appropriate, because most policies will give you an opportunity to go on to, for example, your spouse or your significant other's policy or COBRA.
But do we have an existing law requirements for notice?
There is an existing, if you're dropping health insurance, there is the COBRA provisions that say basically you need to allow the employee to carry over their health insurance. The problem with COBRA for most employees is that it's basically 100% of the premium, and sometimes it's 100% plus the administrative cost, because the employer is no longer carrying that. So for some employees, to pick up 100% of their health care costs, plus sometimes 102% is really cost prohibitive. So in most cases, employees do not COBRA over. If they have a spouse who has health insurance where they may be able to get onto that policy, loss of coverage is usually a qualifying event, so that they can usually get onto that policy if the spouse's policy allows.
Is there a National Association of Labor Commissioners?
Yes, there is.
And has there been anything in your newsletters or anything about instances in other states where this is becoming a problem as people react to the ACA?
We have seen some of that, Senator, and one of the things that I had asked at the time that this issue was brought to my attention by Senator Baruth. I actually asked our wage and hour division and our unemployment claims center, which is here in town, to start recording any information about an employee who was sharing with us information that they were being cut back in hours, and that if they tied it to, I believe this is happening because of healthcare coming online. So we have been trying to track that. We have in our wage and hour division taken a number of calls. I wouldn't say that it's been as significant, but to your point, am I reading about this in our newsletter, which is basically our NASLA newsletter, that's what it's called. I'm picking up stories on that, and I have read some stories on that, yes. Okay. So that's the first piece. The second piece, though, does talk to an employee's rights, and in this case, this would be afforded to the employees of Sodexo if they are choosing, under the National Labor Relations Act, employees have, under Section 7, have a right to self-organize, form, join labor organizations, collectively bargain, and I've underlined the pertinent part, and to engage in other concerted activities for the purpose of mutual aid or protection. So in this situation, if employees of Sodexo were to have come forward to bring this complaint forward, and that is basically for their own mutual aid or protection of their benefits, had they been retaliated against, they would be able to file a charge to the National Labor Relations Board. I note in here that our State Labor Relations Board would not have jurisdiction on this matter since Sodexo's size, amount of business that they do, and the fact that they cross state lines in terms of their business activity.
So how would a Sodexo employee know to file with the National Labor Relations Board?
If they were to call, had any of these employees called our office, because our wage and hour is really, I refer to it, and I've been trying to get our department to refer to as wage and hour employment practices. And we're listed in many of the brochures that are out there that say to employees, if you don't know how to return, you can call us. We will either determine if we have jurisdiction or we'll refer you to who does have jurisdiction. In this case, if they had called our office, our wage and hour and employment division, practice division was put on notice that there may be some concerns coming from Sodexo employees and reminding them about the Section 7 of the National Labor Relations Act. So we were aware that this complaint was there, and we would have advised people.
Where is the National Labor Relations Office?
We're in Region 1, so the National Labor Relations Board for Region 1 is, I believe, based out of Boston.
And there's no Northern New England office?
That would be the New England office.
Okay.
Our State Labor Board, right here on Baldwin Street, also will refer people and explain the difference between the State Labor Relations Act, state labor laws versus federal, and they do a very good job of explaining the law to people and telling them where they can go and who has jurisdiction.
Would they actually help them file something?
No, our State Labor Board would not.
So, I mean, let's face it, if you're working in the cafeteria in Burlington, I mean, how are you effectively going to be able to file anything to the Boston office?
Our office,
Great for your wages.
our wage and hour practice division, I think, would provide enough information. That's part of our job in terms of at least pointing people to what that would be. Telling them, if you call, you would want to be telling them that this is potentially a Section 7 violation. Here's the phone number. You'll be talking to a case intake investigator at the National Board.
So you
Okay.
could,
So they could do it by phone?
Yes, yes,
Yeah,
they can
okay.
do it by phone. They'll eventually have to attest in writing as to what their complaint is, but the initial call can be a phone call to the National Board.
Senator Cummings?
I guess the thing that's bothering me is, I'm assuming these are not high-wage jobs, and what I heard was fear. I mean, if they file this, is their job protected?
If they were to file this, yes, their job is protected.
Their job is protected.
You cannot be retaliated against for filing a complaint. Now, sometimes I will, and I think that some people in the room who are union organizers will know this, that sometimes adverse action is taken against an employee and sometimes the national board, that process can take a long time to resolve. And so sometimes becomes difficult for an employee to do that.
I mean, what I heard is they're afraid for their job. They need to put food in their mouths, food in their families' mouths, pay their rent. They don't have the luxury of hoping the board acts. I mean, if you weren't afraid, you sure wouldn't go to work throwing up in the trash can.
So one of the things that I think as David has constructed the bill before you is actually puts enforcement of this. If you were to craft a bill as it's listed, it prohibits retaliation and it puts the enforcement agency to be the Attorney General's office. And
Yes.
I think it says Attorney General, State's Attorney. It's under 495B, Section Title 21. That is with the Attorney General. The Attorney General also, as you know, enforces the Parental and Family Leave Act in Vermont, the Fair Employment Practices Act, and several other acts in Vermont. Most labor-related matters in the state of Vermont are either adjudicated by the Attorney General's office or the Vermont Department of Labor. Two other points as I listen to the witnesses, if I might comment on. One would be the interplay of what is happening to the employees as I've heard their testimony with the Parental Family Medical Leave Act. And I believe, as you may know how that law works, even an employee, the witness who spoke about her ongoing medical conditions or her chronic medical issue, I believe employees in that situation should always be filing a note attesting to the need for FMLA protection because it does in fact protect employees not only for sort of the large, we often think about people going out for up to 12 weeks with the serious illness of themselves or a family member, but there's also a provision under FMLA for intermittent leave, and that is really to address chronic illness. So an employee who has to receive treatment for a chronic medical condition can file an FMLA letter, a statement for their doctor, and I do believe that it affords significant protection, and again, the Attorney General's office does enforce FMLA violations. So that is another avenue. And
Do you think that the situations described here today, there's a violation of the FMLA?
I think in terms of again, I would think that there is a coverage issue for the employee who expressed the chronic issue. FMLA doesn't cover sort of, I'm homesick with diarrhea today. It talks about serious illness.
Who would we talk to at the AG's office?
I'd say Julio Thompson, who's the Civil Rights Division Director.
Get Julio on here as well.
Because they enforce it and they are very expert in that bill. But I believe there may be some issues, particularly around intermittent leave for chronic illness. So I will, if with hearing, I think what the committee would like, I will continue to look at this issue with David and perhaps pull Tim in from the labor board.
Yeah, we don't want to hamstring employers from being able to run their businesses, but we also, this is ridiculous. It's a situation where they're exposing the public to a health risk by having a policy where somebody's penalized for not coming to work when they're sick. If they're allowed to do that, then we should at least pass some type of health law that would prohibit that. That's just insane. I wish we had a law that wouldn't allow people in the room if they were sick here.
I bet.
I did also look up the labor board case, and I'll give you the site on that if you'd like to read it. This was a case that the labor board adjudicated, and it actually had a majority opinion and a dissenting opinion. But I think it's certainly worth looking at. It's the labor board case, the case of Graham, Graham. And the majority opinion, basically, this is about a state employee who had accrued sick leave, and I actually was going to mention that to David. And you were asking us, how would you define this? 2 points, I'm sorry, I want to step back for a moment. One is, if the employee provides leave, it's called, generally you can refer to it as accrued leave policy. Okay, so accrued leave. In most situations, if an employer does not believe that the employee's use of sick leave is legitimate, in in most cases, the employer has the right to ask the employee to provide a doctor's note to substantiate that illness. Now, it becomes a little bit more difficult if you stay home that day because you've got an upset stomach, you're throwing up diarrhea. You may not go to the doctor for that. So that becomes, and it also becomes a cost factor for the employee. So I think that it should be used appropriately, but there are cases where an employee may be using sick leave to go golfing or to do something that's not appropriate. If sick leave is used, benefit is provided to the employee really is for the use of the employee's sick or usually their family. And you will often see in workforces that younger employees and older employees are heavy users now. You think, why would a younger employee? Because they usually have the small children. And it's the kid that wakes up at 4 in the morning screaming with the earache, and all of a sudden you're like, oh my God, I gotta get into the pediatrician. And the older employees, let's just face it, I'm part of that group, and I know that I'm not as healthy as I used to be when I was 30. So that's where we often see the use. So I just want to reference that that's generally the term. The labor board in this case, in the Graham case, basically said, and this is following the state employee contract, which so they have contractual right, but the board's sort of going down the same thing. It said the issue was whether the grievance use of authorized sick leave during, and this person received an adverse performance rating and was put in a warning status. Whether or not their use of authorized use of sick leave can provide a legitimate basis for an adverse performance rating. We conclude that the grievance authorized use of sick leave cannot provide a legitimate basis for such actions. Employees have a right to use accrued sick leave if they are ill. It is inappropriate for management to penalize an employee in any way for exercising a contractually protected right. Now again, that's a stronger statement because the employees have a contract. An adverse performance evaluation based on authorized use of sick leave certainly penalizes an employee since under the disciplinary action is progressive discipline. Such action would result in at least a chilling effect on the employee's exercise of their use of their sick leave. Anyway, this is the Graham case in the labor board. I can send you that link, David. But what the board was basically saying is it seems incongruous to say we're giving you sick leave but don't use it. And the employee in this case was able to provide doctor's notes substantiating the use of leave in all of those situations. So I think sometimes in the development of a sick leave policy, an employer has to consider what's fair. And again, balancing it with sick leave is not there for you to go golfing, but it is there for you to use when you're sick. And I think that that's the appropriate balance. I don't think that sick leave ties into tardiness, unless again an employee has a chronic condition for which they've provided you that information, and those are separate situations, but regular tardiness is not related to this issue. Sick leave should be able to be used.
Regular tardiness should be excused for termination.
Right, so I'm saying these should not be mixed unless there's a showing. I have an employee who has a chronic condition, and on occasion, morning situations become difficult, and so we are aware of that, and we've accommodated that. She has requested.
But you have a large enough staff that you can.
I do.
There are other situations.
If you're the only person that does the job, and you're the only person with front door key, it's very difficult. So yes. So those are I will continue if the committee would so choose to continue to work with David and as if I think it would make sense to, as you're going to bring in Julio Thompson and
how much time do you think they'll need? Because we'll schedule Julio whenever when you think that.
I already emailed Tim when I was sitting here, and we can check in with Julio.
Okay.
Right away.
So we'll try to schedule a day next week. Sure.
Thank you, Senator. No more questions? Thank you, Senators.
Thank you.